Hello to all our friends at the Academy, and a warm welcome to those of you joining us for the first time. I am Professor James from IntlLaw Academy of International Law. The playlist I am preparing for you will focus on the relationships among the subjects of international law. Together, we will explore how these subjects interact, what kinds of relations they form, and how international law regulates and organizes these interactions. If you're not quite ready to begin this new playlist, I recommend that you first watch the 3 playlists of Introduction, Sources, and Subjects of International Law on the Academy's channel. These were prepared by the other professors of IntlLaw. But if you have already completed those and are ready to start this new journey with me, click on my playlist above to catch up on the previous videos if you want. Or let's dive into today's video by talking about hostile relations in international law. Today, we turn to a difficult yet unavoidable reality of international life. We turn to hostile relations. When we speak about international law, we often imagine cooperation, dialogue, treaties, and diplomacy. We imagine conference rooms, negotiations, and carefully drafted agreements. But history reminds us again and again that relations between states and other international actors do not always remain peaceful. Sometimes dialogue collapses. Sometimes trust disappears. Sometimes disputes transform into confrontation. And sometimes relations descend into violence. The question before us is not whether conflict exists. It does. The deeper question is this: how does international law respond when relationships become hostile? Before anything, I should mention that the playlist of relations of subjects in international law is just aimed to introduce the kinds of relations. So today I just talk about how international law defines hostile relations and what are the branches that govern them. The specific lectures on humanitarian law and criminal law will be created in the future so that you can have a complete course of the subject. Now, let me say that at first glance, hostility and law may seem incompatible. We may think that war is chaos, that conflict is disorder, that violence destroys legality, but international law tells us something very different. Even in moments of confrontation, even in times of armed conflict, even between enemies, law does not disappear. It remains. It transforms. It adapts. In international law, hostility is not the absence of rules. It is a situation in which different rules apply. Even enemies remain legal subjects. Even rivals remain bound by obligations. Even in war, law speaks. To understand this, we must look briefly at history. For centuries, war was considered a natural right of sovereign states. It was a legitimate tool of policy, a means of resolving disputes. Classical international law did not prohibit war. It merely regulated certain aspects of it. During the 19th and early 20th centuries, this began to change. The Hague Conventions introduced early limits on warfare. States slowly accepted that violence required restraint. But the true turning point came after the Second World War. After unimaginable destruction, after millions of deaths, after global trauma, the international community decided that war could no longer be normal. With the United Nations Charter in 1945, the use of force was prohibited. Peace became the legal default. War became the exception. Humanity did not abolish war. It domesticated it. Modern international law regulates conflict through a carefully structured system. We can understand this system through 3 interconnected frameworks. First, jus ad bellum, the law governing when force may be used. Second, jus in bello, or international humanitarian law, the law governing how force may be used. Third, jus post bellum, the law governing responsibilities after conflict. These 3 operate simultaneously. First, there is jus ad bellum, the law regulating the legality of going to war in the first place. Articles 2 and 51 of the UN Charter establish when a state may lawfully use force, whether in self-defense or with Security Council authorization. This branch emphasizes that hostile relations are never free from legal scrutiny, and that the use of force is tightly circumscribed by international obligations. Second, we have international humanitarian law, or the law of armed conflict. This body of law governs what happens once hostilities occur. It seeks to protect civilians, prisoners of war, and those who are no longer participating in hostilities, while also regulating the means and methods of warfare. Treaties such as the Geneva Conventions of 1949 and their additional protocols of 1977 set out these rules. Humanitarian law reminds us that even in conflict, law remains a guardian of human dignity and a tool for minimizing suffering. Then we have international criminal law, which ensures accountability. Individuals, not just states, can be held responsible for violations arising from hostile relations. Acts such as war crimes, crimes against humanity, genocide, and aggression are subject to prosecution in institutions like the International Criminal Court or ad hoc tribunals, reminding the world that law applies even in the heat of conflict. During hostilities, human rights law and refugee law remain critical. The 1951 Refugee Convention and treaties like the International Covenant on Civil and Political Rights continue to protect vulnerable populations, offering a legal lifeline to those affected by war and conflict. And finally, there are frameworks governing the peaceful settlement of disputes and the use of sanctions. Even in the shadow of hostility, the law encourages negotiation, mediation, and, when necessary, collective measures through the UN Security Council, such as sanctions or embargoes. These mechanisms allow states to respond to violations without immediately resorting to armed conflict. Taken together, these branches demonstrate that hostile relations are not a legal vacuum. Rather, they are heavily regulated interactions, with laws designed to prevent escalation, to protect individuals, and to hold violators accountable. A conflict may be illegal under jus ad bellum, yet still regulated under humanitarian law. This creates one of the most important principles of international law. A war may be unlawful, but the protection of human beings within it remains lawful and binding. Law does not reward aggression, but it never abandons humanity. Hostile relations today are no longer limited to traditional wars between states. The landscape has changed. We now observe conflicts between states and armed groups, between armed groups themselves, between coalitions and fragmented actors. International organizations may participate in peace enforcement. Individuals may be held criminally responsible. Private actors may influence conflicts. Hostility today is not simply between flags. It is between complex legal actors operating across borders, often in fragmented and unstable environments. Understanding this complexity is essential for modern international lawyers. Contemporary hostility rarely follows classical patterns. Today, conflict extends far beyond conventional battlefields. We see hybrid warfare, combining military force with cyber operations and information campaigns. We see economic warfare through sanctions, embargoes, and financial pressure. We see proxy conflicts, where states fight indirectly through allies. We see legal warfare, where courts, treaties, and legal narratives become strategic tools. We see gray zone conflicts, designed to remain below the threshold of formal war. Hostility has moved from trenches to networks, from borders to algorithms, from weapons to narratives, yet law continues to follow it. Even in moments of extreme violence, law insists on limits. Civilians must be protected. Prisoners must be treated humanely. Medical personnel must be respected. Attacks must be proportionate. Distinction must be maintained. These are not expressions of weakness. They are expressions of civilization. They represent humanity's refusal to surrender morality to violence. International law does not ask parties to love their enemies. It asks them to recognize their humanity. From the perspective of international law, hostility is not merely political confrontation. It is a legal relationship. It creates rights. It generates duties. It activates institutions. It triggers accountability. Conflicts are monitored. Violations are documented. Courts intervene. Tribunals prosecute. History records. Even in war, states and actors remain part of a legal order. They do not exit it. Today, we have only opened the door and have seen that hostile relations are not moments of legal collapse. They are moments of legal testing. They test institutions. They test principles. They test human conscience. In the coming lectures, the Academy's journey will step further inside this complex world. We will examine how law seeks not only to limit violence, but also to heal its consequences. For now, remember this. In international law, even when relations fall into conflict, law remains present. It watches, it restrains, it judges, it remembers. And it reminds us that even in darkness, norms still exist.